Welcome to the Zebra Family channel. If you have not subscribed, please click the like button, share and subscribe. It's free. To everyone after visiting this channel and commenting, please don't forget to click the subscription button and like. Let us listen to brilliant two minds in court, Justice Theron Adv Ngcukaithobi, arguing a case of Jacob Zuma and the IEC. When two brilliant minds argue the law, it's sometimes robust, heated, and it makes anybody listening to understand the law of South Africa, how it works. This was a brilliant argument from brilliant minds arguing the law in a robust and heated situation. Oh my God, I couldn't believe, I couldn't stop listening. So let's listen to these brilliant minds and see how they argue the law. Then we'll comment after.
I need to find the judgment of the Electoral Court. Do you have the reference in the record? 400. Of 400.
Volume 5.
400, yes.
Thank you, my sister.
Your juniors must earn their keep, Mr. Ngcukaithobi.
So they've now resorted to giving me their own computer. Yes, I am at page 400.
Yes. Do you take issue with the first sentence in paragraph 51? The drafters of the Constitution recognize the fact that a person convicted and sentenced has a right of appeal against their convictional sentence upon leave being granted by the trial court or if refused on petition to the Superior Court.
No.
Do you take issue with the second sentence? If that fact was not important to them, they would not have inserted the proviso which seeks to preserve the status quo pending the appeal processes.
No, we don't. I mean, we've said so in our main submissions.
In other words, they refer to conviction and sentence. I would say, in other words, the disqualification does not take effect until the appeal process has taken place. Alternatively, a convicted person or sentenced person has elected not to appeal.
Yes, we've said so. We agree with that.
So, when courts interpret legislation, they must assume that the legislation must be taken to know the law. Is that right?
Yes.
Now, when we interpret section 47, must we assume that the legislature, when it drafted that section, knew that in terms of our law then, at the time of drafting, every accused person has a right of appeal, subject to leave being granted?
Yes, but they would have known two things. One is that in a criminal trial under Section 35, there are rights because they have drafted them. They would also know a second thing, that there is also the right of direct access because they drafted it. All of this is in the same document.
They would also have known that direct access, which is a procedural provision regarding which forum you can take your matter to, would not trump any other provision in the Constitution. That's what the drafters would have known. And you made that submission a few minutes ago. You said where there is tension between provisions in the Constitution, both provisions must be given full effect. So the drafters of the Constitution must be taken to have known that.
No, Justice Theron, the drafters of the Constitution knew two things. They knew that there's Section 35 because they drafted Section 35. They knew there's Section 167, they drafted Section 167. They knew that it is a procedure, but they knew that if this court makes a final judgment, it becomes a final judgment. So you can't now just write out the other section.
Yes, but the drafters also knew that fundamental rights will not be taken away.
But Justice Theron, you've had that debate already with your colleagues twice. The debate about Section 35 and Section 12. This is not the case to have that relitigated again. That debate has been had. Whether or not a direct access case should result in the imposition of an imprisonment sentence was precisely the point at which you and Justice Khampepe disagreed. So this is not the case to relive that experience.
What we are doing, Mr. Ngcukaithobi, is to interpret Section 47 in the context of the law. Your earlier submission was that legislation must be interpreted having regard to the context.
No, I'm saying
what I am suggesting is that an important contextual factor in interpreting Section 47 is the fact that the legislature was aware of the right to appeal, which is a fundamental right. The legislature was aware that every convicted person would have a right to appeal. The legislature was aware that rights would not be taken away unless that was by specific design.
Yes, but
the legislature was aware that different provisions of the Constitution, where there's possible tension, would be read in order to give effect to both provisions. So if there's a tension between 167 and 35 or any other provision, the legislature was aware that both provisions would be given effect to, as you submitted a few minutes ago. And my concern is that we must apply the law equally and the same in every matter. All principles of interpretation as well should be the same. It shouldn't be said that, like I said a few minutes ago, you said where there's two conflicting or two provisions that have tension, both provisions must be given the full effect. So we can't do that in one case and not in another.
But Justice Theron, you've had the same debate because I've been in this court twice on the same case. This is the view you expressed in the previous two cases. The majority judgment found that it was not taking away any rights. So if you want to interpret Section 47(1)(e), you must take seriously the judgments of the Constitutional Court. This very point that you're putting to me, we've debated it twice. The fact of the matter is that the majority judgment found that merely finding Mr. Zuma in contempt and sending him to prison did not violate any rights in the Constitution of Mr. Zuma. This is an express finding of Justice Khampepe. She said so in the contempt, she said so in the rescission. So now this is a third time where the issue is being resurrected again. And now it's under the new vehicle of Section 47. So we referred to this in our heads of argument at paragraph 43, where we quote specifically what Justice Khampepe said, where she says the Constitution categorically allows the denial of the right of appeal by empowering this court to entertain matters by way of direct access. And that is at paragraph 79 of the judgment. So this debate has been held and it's been settled by majority judgment.
Yes, and that is why I don't understand your submission, Mr. Ngcukaithobi, when you say no rights have been taken away. Because the very passage that you refer to says that the Constitution allows the denial of a right.
But that's not unlawful.
And a few minutes ago, you said no rights has been taken away, and you said that was found, that's what the majority judgment found.
But it's not unlawful. This is the point, because they said it's lawful, it's permitted under the Constitution. So that's not unlawful. So there's nothing wrong in that finding. It's a binding finding of the court. Now, you cannot say, I want to interpret Section 47(1)(e) in order to do that, I must undermine the majority judgment. That itself is a violation of the rule of law.
When this court interprets Section 47, must it have regard to the context that when Section 47 was written, the context was that every accused person had a right of appeal.
Justice Theron, we've debated that 10 minutes ago, and I have said twice that it also knew that there is a direct access provision, and it also knew that when the direct access provision is engaged, the outcome is that you have no right of appeal because this court is a final court of appeal.
Now, apart from the Zuma contempt judgment, where that principle emerged from, is there any other authority for that proposition or principle?
No, the Zuma contempt judgment is the binding authority. That's why we refer to it.
Yes, my question is there any other authority?
No, I submit, Justice Theron, there is no need for us to find other authority because you have a binding authority which is recent.
Finish my question, please.
All right, I apologize.
Apart from the Zuma contempt judgment, where that principle emerges from, is there any other authority in support of that?
No, we don't rely on any other authority. We rely on the Zuma contempt judgment. We say it is binding, it's recent, you should follow it.
My question was not what you are relying upon, Mr. Ngcukaithobi. My question was, apart from that judgment, is there any other authority?
Nothing that we have found, but we say, and this is my submission, you are bound by the judgment. You can't undermine it because you're undermining your own judgments.
Now, if we look at section 47, it does not say that in some instances the proviso will not apply. And I understand that to be what the applicant is arguing, that in this case, in the facts of this case, the proviso doesn't come into operation.
Yes, what we say about the proviso, thank you for that question, and hopefully we can go back to the proviso. What we say about the proviso are three things. Firstly, it's a deeming proviso, and a deeming proviso from Chotabai is that it deems things to be what they are not. Secondly, we say a proviso cannot undermine the controlling section. In order to know the full meaning of the section, you've got to look at the controlling section. And thirdly, we say its purpose is to allow an appeal to take place. But once this judgment was granted by this court, that purpose was fulfilled because this court acted as a court of first and last instance.
If we look again at the electoral court judgment, paragraph 50.
Same page. Yes, I'm there.
The third sentence.
That sentence of what?
Paragraph 50.
Yes, I've got that.
Justice Zondi says, this construction, which the Commission seeks, requires the courts to read in words into section 47(1)(e), the effect of which will be to exclude the operation of the proviso in section 47(1)(e) if a person concerned was sentenced by the highest court in the land. What do you say about that?
No, it's wrong, because the effect of what we're contending for is simply this. If a judgment has been given by this court acting under section 167 as a court of first and final instance, the object of the section, which is finality, has been achieved.
If the legislature envisaged that there would be a class of persons against which the proviso would not apply, shouldn't they have said so?
There is no class of persons from which the proviso doesn't apply. It applies to everyone, including those persons that have been sentenced by the Constitutional Court. It's the other interpretation that creates the arbitrary distinction.
What does the word until mean in the proviso?
Well, it's obvious what it means. It means it's to open up the possibility that the appeal must be finalized, but that possibility has been exhausted once you have made the decision.
Well, it hasn't been exhausted. It wasn't granted. There was no possibility of appeal.
Yes, but
so the proviso never kicks in.
That's the consequence of the fact that you exercise original power and you exercise direct access power. So what that means is that finality, the section is there to preserve finality, but finality is achieved as soon as this court makes a decision.
On the assumption that Section 47, that the drafters of Section 47 had in mind that every convicted person in sentence has a right of appeal, subject to leave being granted. Let's leave out the possibility of being sentenced by this court with no possibility of appeal. What possible interpretation would there be to Section 47?
No, but even with that construct, sorry, Justice.
I think, Mr. Ngcukaithobi, I've been watching for a while, keeping quiet. It might be helpful just to tone down a little bit. You come across as being very irritated and impatient with Justice Theron, and it's not seemly. Just relax and let her finish her questions. You're not going to get questions you like all the time. Just answer the question,
I apologize, Deputy Chief Justice. Sorry, Justice Theron, I should be apologizing to you.
Mr. Ngcukaithobi, I know you mean no offense,
Yes,
so I take now.
Yeah, no.
We have walked a little way
Yes,
together.
no, I know. Yes.
Okay. On the assumption that the drafters of Section 47 had in mind that every convicted and sentenced person would have been afforded a right of appeal. Where a person has not been afforded a right of appeal, what options would be open to this court as to how to interpret Section 47(1)?
I was saying, even on that construct, even on the construct you have given, you still have the possibility that a criminal trial takes place in the magistrate's court, takes place in the high court. This court decides that the sentence is too lenient and it imposes an original sentence. You still come back to that point. If they are correct at the electoral court level, that means you strike out the entire Section 47(1)(e).
Sorry, I only heard the last part where you said, if that, and then I missed some words, you said, it means strike out the last part of 47(1)(e).
No, I'm saying that even on that construct, in other words, a construct in which we have a full trial before the magistrate's court, and a full appeal before the high court, and a full appeal before the Supreme Court of Appeal, you still have the possibility that this court has the power to impose its own sentence if it believes that the sentence originally imposed is too lenient. So you come back to where we started, which is there is no way in which you can interpret that section as excluding sentences imposed by the Constitutional Court.
But that would be an appeal, that would be a sentence altered on appeal. It would not be a sentence as an original sentence. While we're on that,
Increased sentence.
the Magistrates Court gets its penal jurisdiction from the Magistrates Court Act. The High Court gets its penal jurisdiction from the Superior Courts Act. As I understand, the Supreme Court of Appeal does not have penal jurisdiction. Where does the Constitutional Court get penal jurisdiction from to impose a sentence as a court of first instance?
Well, you've exercised that power because you were exercising original constitutional jurisdiction, and you imposed it in the context of Mr. Zuma, the same as exercising the power as an appeal court. The Supreme Court of Appeal has done so several times, and we can refer the court to its many judgments where it increases the sentence as opposed to examining the sentence imposed by the lower court as a court of appeal. So the law is clear that even the Court of Appeal has penal powers.
Yes. I'm not dealing with the powers of a court of appeal or the powers of a court hearing an appeal. The power to decrease or to increase a sentence. Talking about a power to impose an original sentence. and the penal jurisdiction that grants the court that power.
Yes, but Justice
And
Theron,
if I understood your answer was that this court would derive that source of power from its constitutional jurisdiction.
yes, I'm saying the Constitutional Court derives original sentencing power from the Constitution itself. It has exercised it in the Zuma case.
And does this arise from the direct access provisions?
Yes.
And so you say from the direct access provisions, this court derives original penal jurisdiction.
Yes, but it also derives it from Section 172, just an equitable remedy, where it has found that the Constitution has been violated. And in the case of Mr. Zuma, it was a direct access provision, and it had found that its own judgment was violated, its own authority, its own standing was threatened, and it exercised original constitutional jurisdiction. In fact, if you look at if you look at that page 71 I was referring to earlier, it's page 71, not paragraph 71. If you look at the order itself, it's at page 70, paragraph 71. It was a declaration, paragraph 3. It is declared that Mr. Zuma is guilty of the crime of contempt. And then Mr. Zuma is sentenced to undergo 15 months imprisonment. So the court did exercise original sentencing power.
If I can take you to the Sibia case.
Sibia.
Yes.
I'll have to find it, I'm afraid. Anyway, let's hear what the substance of the issue is.
The respondents rely on a following passage from that case. I think it's at paragraphs 40 to 43. It says, the president does not determine the sentence, but merely imposes it. And then a few lines down, it says, the president substitutes the sentence recommended by the judge in a situation where the person whose sentence is
Sorry, Justice Theron, where are you reading? I'm sorry to stop you, but I don't know where you are reading from. Which paragraph?
It's a paragraph that's quoted in the respondent's heads at page 120.
All right. Which paragraph of Sibia? I've got Sibia in front of me.
Can I read?
It's 41. Yeah. Yes. It's paragraph 41.
Yes. The president substitutes the sentence recommended by the judge in a situation where the person whose sentence is substituted has already been tried, convicted, and sentenced, a person in respect of whom the judicial process is over. And I suppose the applicant would support that position regarding remission.
Sorry, Justice Theron, you'll have to put that again because I've just looked at the facts of that case. It was a case about substitution of death sentences. So, which has nothing to do with the power of remission.
The respondents rely on it in respect of the doctrine of separation of powers.
So we don't take issue with the doctrine of separation of powers. What we say is that if you apply the remission, because Mr. Zuma did not get a commutal of sentence, you'll see in that judgment, it's paragraph 18. It's a substitution of a sentence of death. And historically, it has always been acknowledged that the president, as head of the executive, is entitled to commute a death sentence to a sentence of life imprisonment. That has nothing to do with a remission, which is what the case is about. This case is about a remission. The question for a remission is a narrower question, which is whether or not the effect of a remission is to amend the original sentence. And the problem here, Justice Theron, that's probably a good thing you've raised this point. The problem here is that you have the electoral court finding that the sentence was 3 months. And it makes that finding without any textual support, either in the judgment of this court or even in the decision on remission. It imposes its own sentence retrospectively. And then, that's number one, the clear distinction. And then you look at what is the law on remission. The law on remission is the remission simply impacts the duration of the sentence to be executed. It does not impact the original sentence. What is the position of section 47(1)(e)? 47(1)(e) is clear. It is not about the original sentence. It is about the original sentence. It is not about the execution of the sentence. So I'm afraid Sibia is irrelevant.
The respondents say that, or they criticize the applicant. They say section 47(1)(e) is concerned with the length of sentence imposed. Just a minute. It criticizes the IEC. It says that the IEC does not provide any authority for the submission, that section 47 is concerned with the length of sentence imposed and not sentence served.
We've dealt with this at length. Firstly, we have said it's the text, because the text says sentenced. It does not say sentence served. Number two, we've said it's the object behind the text. Who sentences? It is only a judge that can sentence. Whatever the president does about a remission, he cannot sentence. He can always impact the length of the sentence to be served. But what he can never do, he can never sentence. Section 47(1)(e) is about who sentences, and only the court sentences. And then we have drawn the court's attention to what the drafters of the Constitution thought about remissions.
I may be wrong, but it seems to me that both the applicant and the respondents rely on Smith and Boshego.
We don't rely on Smith and Boshego. We just say that they've been incorrectly invoked.
Do you say they're not applicable in this matter?
Yes, they are inapplicable because those judgments were about parole. This is not a case about parole. In fact, Mr. Zuma disavowed parole. We have no problem that a remission has the natural effect of reducing the sentence that you serve. I mean, that is clear. You get out of jail. The issue is, we say that parole does not affect the original sentence. Section 47(1)(e) is about the original sentence.
Thank you, Mr. Ngcukaithobi.
Okay, my take in listening to this brilliant minds arguing the law, it makes one understand that when you argue the law on merit, it helps the next person to understand that you can disagree in a lot of things, but everything must be based on law. I would like to ask my audience to give their opinion as to how these two brilliant minds argued the law, and who do you think came on top in this argument? Let's comment respectfully and make sure we don't forget to go to that red button, like, subscribe, share, and make sure you do it with respect. Bravo, 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 bravo.